Welcome, everyone. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome again, everyone. Our first item tonight is the approval of the minutes. We'll go a little out of order. Motion to approve the September 2nd, 2014 work session meeting minutes, the October 20th, 2014 regular meeting minutes, and the October 20th, 2014 executive session meeting minutes.
I'll move that motion.
We have a second?
I have to actually abstain on the work session.
Okay.
I'll second.
All right. All in favor of September 22nd, 2014 work session meeting minutes?
Aye.
Aye.
Abstain.
All in favor of the October 20th, 2014 regular meeting minutes?
Aye.
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 And the October 20th, 2014 executive session meeting minutes?
Aye.
And as to the October 6th, 2014 regular meeting minutes, we can make an amendment at this point?
I move to amend the October 6th minutes as follows. There's two amendments. On item 12, there was an error in that Susan and I were both reported to have moved that motion. I believe Susan moved and I seconded, and the clerk has corrected that in an amendment that has been sent out to the council. And then in item 23, I can't recall the original language, but the proposed language now reads, Mr. McLaughlin remarked that maybe the night could be changed and the room that the meeting is currently held, and proposed adding alternates. Glenna M. Hagopian commented she believed that not appointing former alternate an open position was insulting and led to his resignation, leading to the meeting needing to be canceled, but indicated that other alternates had now been appointed in this situation should not recur. So if everybody is okay with those amendments, I'm happy with that, and the clerk has in fact circulated that.
So what about on those?
Makes sense. So with those amended minutes, motion to approve the amended October 20th, 2014 regular meeting minutes. That motion has been made?
Right.
Seconded?
I'll second it.
All in favor?
Aye.
Motion carries 4-0. Next item is an announcement recognizing town council members. Ms. Nolan.
Yes. We would like to recognize the two council members who are leaving us, not running for office for town council again, and for serving the community and for being good council members. I'd like to read the first one, honoring James M. Callahan. Whereas the citizens of this community possess a spirit of concern for others and devote countless hours towards the improvement of this community, and whereas our community benefits from the active involvement of its citizens, those men and women who commit their time and energy to making their town a better place to live, and whereas James M. Callahan has served as the president, the leadership role of the Narragansett Town Council since November 2012, and whereas James M. Callahan has earned the admiration and high regard of those with whom he has come into contact with and of his fellow public servants, therefore, let it be proclaimed that the members of the Town Council, Town Administration, and employees and citizens of Narragansett express our appreciation and thanks for the distinguished service to the community and highly commend him for the manner in which he has carried out his duties and responsibilities.
Thank you very much.
And I will read a second one to Glenna Hagopian. Whereas Glenna M. Hagopian has served as a member of the Narragansett Town Council since November 2008 and presiding as president for the 2-year term of 2010 to 2012, and whereas during her tenure, she devoted her time and interest to matters affecting the financial stability of the town, and whereas Glenna M. Hagopian determinedly initiated the establishment of the Citizens Finance Committee to provide oversight of the town's finances and ensure transparency in the government finances, and whereas by playing a direct role as the member of the town council, Glenna M. Hagopian, stands as a reminder that all people have the power to make a difference in building a responsive and successful community. Now therefore be it proclaimed that the members of the Town Council, Town Administration, employees, and citizens of Narragansett recognize and applaud Glenna M. Hagopian for her distinguished service and wish her continued success and good fortune.
Thank you very much.
both.
So, I want to take a picture.
Thank you, Pam. Thank you very much.
Thank you very much.
So Pam, can I just add to that, because there's a little something here for the president of the council. We just want to thank him for his leadership for these last 2 years, and it's been an incredible time here on the council with Mr. Callahan. So just a little thought, maybe you could open us pictures of Narragansett.
Well, thank you very much, Ms. Bonanno, and I appreciate very much your service as President Pro Tem. And of course, Mr. McLaughlin. Oh, thank you very much. It's beautiful. And Ms. Hagopian, and of course, Mr. Mannix. It's been a great experience. Met a tremendous amount of people. Heard a lot of voices. Mr. Wojciechowski's, Mr. Alba, Mr. Vangermish, of course. It's been a great time. Done a lot of interesting things and dealt with a lot of interesting issues. And I think the town people really are engaged and interested in everything we've done and have let their voices be known. So it's been an honor, and I will miss it. And thank you very much. And Ms. Hagopian, good luck in your future endeavors. I was thinking about your term the other day, and I think that your financial acumen regarding town business has been a real asset. But I think, surprisingly, what might be your legacy is the purchase of Middlebridge, because I was driving over that a few weeks ago, and it really is beautiful. It's a great place, and I think in years to come, that will be something's remembered for a long time as a preservation, something that will benefit the town for generations. So congratulations and good luck.
Thank you very much. Good luck in your race.
Thanks.
It was a great handoff to you. You were a wonderful successor and obviously a true diplomat. I wish I had your measured approach to things. I think, I think you really set a tone, and likewise, it was an honor and a privilege to serve this community. I learned an awful lot about the town. I was relatively new to the town when I was elected, and learned a lot about the community, but also learned a lot about what it had to offer, but the passion that the townspeople have to preserve the community, the financial stability, and to really the assets, the health, the values, and the beauty, just the sheer beauty of it. So thank you very much for everything you've given to me in my tenure here, and I won't stop watching. I won't stop being involved, and who knows what next couple of years might bring. Thank you again.
And we'll move on, as we always do, to the open forum. Please state your name and address upon approach. Mr. Wojciechowski.
I will truly miss you. I'm really sorry that you're leaving. I know on to bigger and better things, I hope, for you both. I just want to finalize data. I want to talk about data. I have to give a lecture, I guess. Data. My professors always said data is important, confirmed data. That was always the big thing. And I had a tour through the police building, and after the tour, it was obvious that I had to change my decision on that bond issue, and based on data. If you get new data, you've got to make the changes necessary. It was obviously that we have a legal issue down there. We're on notice. It's a legal issue, And, I can just vision a Levine-type lawsuit, and that could be $1 million lawsuit problem. And based on that, I have to change my decision on that thing. And I'm standing here to any voters that might be out there, that has to happen. However, on the school, I want to just hit the school one more time on this issue. I think I look at families will move into the town. Families will move into the town when we provide a year-round school, when we provide 8 hours a day schooling, when we provide them something extra in education. I think we need to focus on that. And I think the smart families would look at that more important than teaching their children to play. And the data would probably tell you that excessive playing could result in concussions, leg injuries, knee injuries. So there's some negatives. Again, the data would tell us that our decision on that has to be to maintain it, fix the field and bleachers with the money we have, but excessive money spent on what we're doing. I'm not so sure how long this turf is going to last. Is an 8-year life on this thing? Is there some physical problems that could happen because of the compounds within that and the maintenance? I'm not so sure that we're in the right direction there, and we'll have to hold fast on that one. And finally, data. I'd be very upset when I hear about student problems, college problems, URI problems. The data says, well, somebody mentioned the data, 107 issues out of 2,100 rentals. That doesn't sound like a rental problem based on data, or a student problem. However, I can see that if you go to these problem areas, I think maybe 100% of them are caused by drunk people. Therefore, the data says we have a drunk people problem, and I get offended and upset when the paper starts saying we have a student problem or a rental problem. No, we don't. We have a drunk problem.
Mr. Wojciechowski, your time is up. Your time is up.
And the university
That's it.
also confirmed that by saying 1/3 of the students come in have that. So we really got to look at how we go in the future, really.
He
wanted
said
to end
he
this-
said he never used it, so I had to use it on
I
once.
really wanted to end this with a gavel. That's so good. I want to thank you very much.
Mr. Durkin.
I just wanted to wish the members that won't be here tomorrow good luck. I just wanted to thank you as a council for supporting my project and the Break Hotel, which will be open in the spring. And just wanted to thank you and wish you good luck to whoever's moving on and whoever's not.
Thank you, and good luck to you, too. Mr. Alba.
Al Alba, Eagles Nest Terrace. Well, like he said, he wants to thank us for letting him build this hotel, yet he objected to my nephew's, Iggy's, hotel right down the line, when his was the same situation that my nephew had. So he had no reason to object to it. And also, I wanted to remember to bring up the fact that the sign has been down stating how do you get to the town hall here. So it's been down for quite a few weeks now. So if you want to come up here, you have to kind of guess which turn to make. So it would be nice to get that set up right.
So, Pam, you could maybe see about that sign being put back up?
Yes.
Thank you.
Okay, and also like the last meeting we had, there was, I can't think of her name now, but she was thinking of being able to buy some a beach pass for her tenants. That would be a nice thing to have. So they would have to go to Washington Trust place there. So that would be a good thing to be able to have tenants come to Narragansett Pier. So it would be a good thing. Thank you very much.
Thank you. Yes, ma'am.
Good evening. My name is Judy Castellucci, and I live at 50 Major Arnold Road here in Narragansett. I refer to a project under construction on Major Arnold Road at Plat L 1-14. I would like my comments to be a matter of record and speak only in consideration of this travesty never happening again in our beautiful town and neighborhood. I have researched the files and attempted to hire a lawyer to appeal the issuance of a building permit to no avail because of loosely written regulations regarding footprint and height restrictions that give little consideration to the surroundings and size of lot being built on. My abutting neighbors, 7 of 10, have me speaking here tonight because they too are just as devastated that the zoning board approved this project in the first place. All the expert witnesses, mainly the words of an engineer and real estate expert and not the owners affected, were used to help make the determination. Mr. Frisella testified that the proposed home is slightly smaller than current homes in the neighborhood. He also stated that although he did not prepare the house plans, to the best of his knowledge, exhibit number 3 represented the house proposed. The real estate expert, Jerry Sahajian, who also was the agent involved with the sale, and to me represents a conflict of interest, said it was in harmony with the general purpose and intent of the zoning board. In addition, he stated that there would be no negative effect on property values. In an environmental questionnaire, their answers to questions submitted for a yes or no answer were as to number 8, the visual character, that this project would not affect the visual character, scenic views, or vista, nor was there a need for a public hearing. These experts were referring to the site plan and drawings submitted by the original owners back in 2011. The property was sold as soon as the zoning board approved the application. A comment made by, and I quote, Mr. Jason Parker, an environmental planning specialist, when a staff reviews an application that deals with a parcel that is small in size and impacted by erosion or wetland, they always recommend on the conservative side and the approval of a smaller house and the least amount of variances necessary. There were 9 variances necessary to make this project possible, and only 50% of this small lot was available to build on. It should be noted at this point that the house the new owner submitted building plans for is entirely different than the proposed plan, which was originally approved and referred to in all the recorded documents. A building permit was issued on September 12, 2014. Abutting owners did not find out about this until several days later when the project was about to begin, and immediately went to the town hall for information, only to discover that the new owner was building a 3-story box on this tiny lot, not even close in design to the one that was approved. Within approximately 2 weeks, this monster house is up and completely obstructing the water view from 4 abutting properties and totally out of character for the single-family community of 40 years. There are actually 7 properties affected by the approval of this building permit. We abutting property owners were not given a right of appeal when these new plans were submitted and would have challenged the issuance of a building permit. After consulting an attorney, it was advised that due to the existing format and standards that the town imposes on construction, it would be difficult to win this case. Also, there was no time left to present an argument, as the 30 days allowed to appeal a building permit were up in the next few days. The new owner previously had told us he was building a small home as he was given many restrictions. We all assumed that he was talking about the original plans submitted and had no idea until he asked for his building permit that his plan was entirely different, and we felt deceived. We feel a height restriction should have been warranted based upon the original information that was given by the experts as it pertained to the original documentation submitted and approved, which showed a two-story home. The hearings on this project were continued twice during the initial process, making it difficult for owners who already had set aside time to attend those meetings to keep returning. Some within the immediate area never got notification of any hearings, and then it became a closed hearing set for March 24th, 2011. At this meeting, it was announced that a quorum had not been met on February 24th, therefore a decision could not be rendered. Again, on the 21st of April, there was no quorum, and a meeting was rescheduled for April 28th, 2011, at which time a decision was rendered and essentially left us powerless to fight without legal representation, which appears to have more power in these hearings than the neighbors a project like this affects, and I might add, an expense that we could not afford. The process was lengthy, with all the continuances and lack of a quorum twice, and a meeting that went on so long that when we were finally given a chance to speak, we were cut off because of the late hour. And then it became another closed meeting, and a decision was made behind closed doors. This is not what I expected of our zoning board, and the limited opportunity that we were given to object strenuously to this project. It would appear that the zoning board should reevaluate its rules pertaining to oceanfront properties in the future. Our valuable oceanfront is being destroyed and should be protected more closely. On such a small lot, there should have been tighter restriction as to the height imposed. The aesthetic appearance is totally out of proportion. Surrounding neighbors set back...
Ma'am, you're going to wrap this up? Your time is up.
Yeah, I've got one more paragraph. Surrounding neighbors set back from the ocean have sometimes chosen to build up to the height limit to avail themselves of an ocean view. But is this necessary on an oceanfront lot? I tend to think not, since the owner would have had an unobstructed view even with a one-level home. If this story can help someone else faced with a similar situation by bringing this case to the public, then our frustrations and disappointments will perhaps make this board stand up and take notice of zoning regulations and procedures and reevaluate them for an upgrade based on individual circumstances. It is not enough sometimes to require only to keep within a footprint and height restriction, as this can destroy a neighborhood. The fact that our town does not have an architectural review board should be taken into consideration as a solution to preventing this from ever happening again. I would like to thank you for giving me the opportunity to express an opinion on some shortcomings, and hope you will take the opinion of a group of owners in the Fort Nathaniel Green neighborhood seriously and perhaps consider changes to zoning regulations in the future.
Thank you very much.
Respectfully submitted.
Thank you.
And I enclose with this the picture of this little monster.
Thank you. Looks like that's it. I just want to, again, thank Ms. Bonanno and Mr. McLaughlin for all their hard work in the past 2 years in the council. Like I said before, it wasn't always the easiest road to go, but I think you both performed admirably in all aspects in every meeting, and there were dozens and dozens, whether it's special meetings, budget meetings, work sessions, or anything else. So again, I just want to thank you both for your service, and good luck tomorrow as well. I think that's it for the open forum, so we'll move on to the public hearing. Motion, can we move on? Do we have to wait till 8 o'clock, Mark? Is that? Okay. Move on to the consent agenda. We can get through that. Anyone have any items to remove from the consent agenda? Motion to approve the consent agenda?
I'll move that motion.
Second?
All in favor?
Aye.
Aye. Old business number 3, a motion to adopt an ordinance and amendment of Chapter 46 of the Code of Ordinances of the Town of Narragansett, Rhode Island, entitled Miscellaneous Offenses.
I'll move that motion.
Second?
Any discussion? All in favor?
Aye.
Number 4, a motion to schedule a hearing to approve a request from Gilbane Development Company on behalf of GP Pier Retail LLC for the approval of plans to renovate the exterior of Building D in the Pier Market, which would include a new roof with cupola, siding, and windows.
I'll move that motion. Do you have a date?
What is the date? Yeah, I'm sorry. 11/17?
Oh.
Any discussion?
I'll second it.
So the motion's for 11/17. All in favor?
Aye.
Aye.
Motion carries. Number 5, a motion to approve the updated job description for Clerk 4 position.
I'll move that motion.
Second?
Discussion? Ms. Nolan, do you want to give us a short explanation on that?
Yes, nothing's changing in the job description except when an employee can become a clerk 4. It was changed during council, or union negotiations with Council 94, and it goes from being a clerk 3 for 6 years before you can become a clerk 4 to being a clerk for 6 years before you can become a clerk 4. And it still requires the recommendation from the department director and from the town manager to become a clerk 4. So this is something that you approved when you approved the contract, but we have to officially approve the change in the job description also.
All right. Any further discussion? All in favor?
Aye.
Motion carries. Regarding number 6, 7, and 8,
I'd like to make a motion that we postpone those appointments till the next council, give the new council an opportunity to review them and make the appointments.
I feel the same way. I'd second that motion.
Did you just second it?
I'll second it.
Okay. Yeah, I think that's, would be appropriate. I mean, tomorrow's the election. There's some appointments and some reappointments, and I think in light of we don't know who's going to be sitting here, I think it would be left up to the new council, so I concur.
It's almost like the midnight appointments,
Yeah.
Marbury versus Madison or something like that.
Ms. Galva has his hand up.
Mr. Alba?
You went on too fast on the Gilbane development. You know, we've been taken by him in the past, and I think we should look into his development. I mean, that's supposed to be like a mystic village, where he built all those apartments there that, so you can't take him at his word. So make sure you look into that it's gonna be done the way it's specified and not any other way. Thank you.
Thank you. Any discussion regarding the continuance of the appointments, which is 6, 7, and 8? No. I think we'd continue it to the second meeting. Does that make sense?
You might want to give the new council a chance to at least get their feet wet. There'll be a couple new members anyway.
Right. December meeting?
I think it's December 1st.
December 1st? So motion to table the appointment to the Recreation Board, appointment to the individual, the Pension Board, and the individuals to the Personnel Board to the December 1st meeting? Is that what you said? December 1st meeting?
I'll make that motion.
Second.
Any further discussion? All in favor?
Aye.
Aye.
Nay.
And actually, we can move on to the public hearing at this point. A motion to schedule a public hearing for the application for a transfer of Class BV liquor license from George's Galilee, Inc. restaurant doing business as George's of Galilee, President Elton Durfee, to George's Galilee Restaurant, Inc., doing business as George's of Galilee, President Kevin R. Durfee, for a stock transfer. And what's the date for that? December 1st. December 1st? Someone like to make that motion?
I'll make that motion.
I'll second.
Any discussion? All in favor?
Aye.
Motion carries. We also have a public hearing on the renewal of the 2013-2014 liquor licenses, which I think is most of the reason people are here tonight, So we'll take the Class A beverage license renewals. Well, actually, we'll open the public hearing. Someone like to make that motion?
I'll make that motion.
I'll second it.
All in favor?
Aye.
Aye. So the first items are the Class A alcohol beverage licenses, which include Bonnet Spirits, Boston Neck Road, 965, Bonnet Liquors, O'Neill's Package Store, Inc., South Pier Road, 366, O'Neill's Package Store. Also Pier Liquors, Pier Marketplace, number 29, Pier Liquors, and Schwabi's Wine and Spirits, Inc., Point Youth Road, number 855, Schwabi's Wine and Spirits. Someone can make a motion to renew the 4 Class A beverage licenses for those establishments.
I'll make that motion.
I'll second that.
Any discussion? All in favor?
Aye.
Aye. Motion carries. The Class B victualling limited alcoholic beverage licenses, there are 4. Aunt Carrie's, Inc., Ocean Road, number 1240, Aunt Carrie's. Casey Montanari, Bone Street, 148, The Bike Stop Cafe. JB Coffee Company, LLC, Kingstown Road, number 18, Cool Beans Cafe. And Julio's, LLC, Boston Neck Road, number 909, Leo's Pizza. Someone can make a motion to renew those 4 Class B limited alcohol beverage licenses.
I'll make that motion.
Second.
Any discussion? All in favor?
Aye.
Aye. Moving on to the Class B tavern alcohol beverage license renewals. There are 4 as well. Actually, there's 3. 3 or 4?
4.
It says 4 on top and 3 on the bottom, so I guess there's 4. So we have INP Beverage Services, Ocean Road, number 113, Ocean Rose Inn. Pry X Beverage Services, Great Island Road, number 307, Lighthouse Inn. The Break LLC, Ocean Road, number 1208, The Break. And Recreation Partners, Inc., Beach Street, number 1, Village Inn, Oceanside, Amalfi's.
I'll make that motion.
Second.
Yeah, there are people who want to speak on that license, James, I believe.
Sure, open discussion.
Yeah.
Mr. DeSimone?
Good evening, Mr. President, members of the Town Council. I represent James D'Ambra, the Bonneview Restaurant, and numerous other objectives that are within the 200-foot radius of this proposed renewal. Additionally, let me say, most importantly, I did some research on this particular liquor license, and it appears that this liquor license was granted, in my opinion, and I know you have competent counsel here, but the liquor license was granted illegally due to the fact that the use code 5813 does not permit a Class B license in that zone. So I would submit to the Town Council that you have ordinances on the books that don't permit that type of license. Certainly, he has the ability, but he'd have to apply for a use variance, and that has not been done as of yet. Secondly, when he came to you originally last year, he provided a parking plan which called for valet parking to lots which are currently have houses on them. So you can't have 2 uses for valet parking when you have houses on that property. Obviously, you know that would be against any type of zoning regulation. So he'd have to apply, again, for some type of zoning variance, which he hasn't done as of yet. So I would ask the board that at this time, since the project is not completed, he's in the middle of zoning right now, there's a zoning hearing scheduled for November 10th, it appears to me that there's ample evidence here that he would not meet his prima facie case for a renewal. And in fact, I think that if the zoning board, if this particular board, sitting as a licensing board, would grant a license here, you would be violating your own ordinances. So with that, if you have any questions of me, I'd be glad to answer them.
I have a question.
And, my co-counsel here, Jim D'Ambra, just reminded me, in his current application for zoning, he subdivided the lots, 237, 237A. There's already an existing liquor license at 1200 Ocean Road, I believe it's Narragansett Grill. There was a variance granted in 2003 for that liquor license. In that variance, the zoning board required certain parking. In the variance now, for the current variance that hasn't been decided by the zoning board, Mr. Durkin is occupying 5 spaces of that lot for his hotel. And he's also occupying land, approximately 2,900 square feet for utility power, generators, things of that nature. So I would submit that if you grant him a renewal for this particular application, you would be having 2 liquor licenses on the same lot. I can't think of any zoning board or council sitting as a licensing board that would do that. So I would ask that you at least take under advisement some of the facts that I've brought out to your attention. He essentially will have 2 liquor licenses on the same property. And the one that he's currently asking for renewal, he hasn't even taken out any type of building permit, so there's really no rush for you to act. So if you have any questions, I'd be glad to answer.
I have a question.
Sure.
You made reference to valet parking and parking on where there are houses.
Yes.
Specifically, what violation of the zoning regulations does that apply to? And I
Well-
make that point because over in Eastwood Look, we have an entire neighborhood where every yard is packed full of cars. And
Well-
the information I have is that it isn't in violation of any zoning regulation.
Yeah, well, it is, and there's a couple
Could you
of
tell me
things.
which one it is?
I don't have that particular one off the top of my head, and I don't have it, but I can tell you, I'm sure your solicitor can tell you that you cannot have a residential use, meaning a house.
They're all residential homes over there with vehicles parked in them.
Well, then, they may be grandfathered in, I have no idea, but I can tell you that you cannot have parking with a residential use on the same property. I mean, he could apply for some type of variance. I don't know if the parking lots that you're talking about did do that.
No, they're not parking lots, they're residential homes that
Right, I don't know if they did do that.
have 20 people living in the homes that park their cars all over the property.
Right, and I believe the building inspectors also said the same thing, but your competent legal counsel
Am I
here-
correct when I say that? There isn't anybody, does anybody know that, to be sure, Mark, that's my understanding anyway.
As a general rule, I don't know, I haven't looked into the facts of this, because I was not at the zoning board, but as a general rule, on a residential lot, you can't also make use of it for commercial purposes, so you can't rent out for a business on your house. That's generally the rule in zoning. I'd have to look at the facts of what is being claimed here. I'm not sure what Mr. Durkin's attorney is going to say otherwise, but as a general zoning rule, you can't have a commercial and a residential use mixed on a residential lot.
Okay. Thank you, Mark. Thank you, Mr.
That's-
DeSimone. Thank
You're
you.
welcome. That's pretty well settled. And I would submit to you that the parking that he's going for, the variance that he's going for with the hotel and zoning, he doesn't reference any valet parking of any other lots. He's actually using 5 parking spaces on the 1,200 property, which is currently occupied by a liquor license. So, I would just submit, I know I'm throwing a couple of different ordinances out to you, and I would submit that this is not ripe for you to make a decision tonight. And, I think the most compelling argument is that Section 5813 just does not permit the use that he's asking for in terms of a liquor license. You can't have a bar, a cocktail bar, anything like that in that zone, and that's a BA zone. So I would submit to you that the license that you gave him last year was most likely against your ordinances. And while he prima facie, under the law of Rhode Island, a renewal is prima facie renewed, I would submit to you that by me giving you 5813, that certainly meets the burden of prima facie, because he hasn't even opened yet. so there's really no foul to him. If Mr. Durkin wishes, he could apply to the zoning board and get whatever appropriate relief he needs, but I would submit to you it would be a use variance, which means he would have to prove that he has no beneficial use of the property unless he gets the liquor license, which, you know yourself that he still has the hotel, so I don't know how he could ever meet that burden. So if you have any other questions, Mr. President, members of the council, I'd be glad to answer.
Thank you.
Thank you.
Mr. Doherty.
How did you guess I would address these comments? I think what you've heard has been a misconstruing of the law and the ordinance by my brother here, Mr. DeSimone. To begin with, there was no variance granted for Lot 237 get a liquor license, number one. And there was no intrusion on the parking requirements of that lot. What they're trying to do here is they're trying to bring up issues that are before the zoning board and that have been decided by the zoning board and that have been decided previously by the council. To begin with, Mr. Durkin did not subdivide the lot upon which the break is located. That predated his ownership. It was a subdivision that went through planning and it received approval as a minor subdivision. In addition to that, the land, when it was subdivided, complied in all respects with all zoning requirements and planning requirements. Insofar as the allegation that my client is somehow intruding onto the necessary parking requirements of what is now the Narragansett Grill property, which there is a co-identity of interest between the two entities that own the break property as well as the Narragansett Grill property. They're both owned by my clients, the Durkins. Separate ownership, different LLCs. One is the Break LLC, which is the hotel lot, and the other one is VP LLC, which is the Narragansett Grill location. But in no way are the necessary 34 spaces required by the zoning ordinance and required by the liquor license on the Narragansett Grill being utilized by the break in any way, shape, or form. It's very difficult to have these issues coming out of the blue and not having the benefit of having a blow-up of voluminous exhibits and whatnot, which can show this to you. But I would posit to you that those are issues that are before the zoning board. They've raised them at the zoning board hearing. I don't think they're getting much leverage or mileage out of them there. And now they're just trying to muddy up the waters here. What's going on here is, I think, a long-standing feud between Mr. D'Ambra and the Break Hotel that preceded my client's...
You'll have your chance to speak, Mr. D'Ambra.
That preceded my client's ownership. I mean, Mr. D'Ambra sued every member of the zoning board individually. They sued them for constitutional violations. They did everything within their power to appeal, to try and stop that decision. My client purchased the property with a special use permit in effect and in full validity for the construction of a 16 guest room boutique hotel. And he's upset about that. He's been here at every one of the hearings before the town council raising all kinds of issues. He's been at every planning board hearing. He's been at the zoning board hearings. I can address more of the merits, but I also noticed that you see Mr. Gravino over here that's sitting there, who's, employees up here whispering things to Mr. DeSimone. My client, as an abutting property owner of the Iggy's property, which is owned by Gravino LLC, objected to the application on the basis that they were looking for less than 50% of parking to be fulfilled in his application, and he was concerned about his ownership of those little fishermen's cottages in the present Iggy's location, which will be adversely impacted by the construction. We put on a case, the zoning board ruled against us. However, there's been a vendetta going on, and they're here again carrying that out. Back to the merits of this, the allegations that were made. The hotel is almost complete. The hotel has been built out in reliance upon decisions issued by the zoning board in 2013 and in reliance upon the receipt of a liquor license by this council. If there were objections to that, the time to have made those was last year and also earlier this year when we were before the council seeking a transfer of the license from Rebecca Durkin doing business as The Break to The Break LLC, a separate entity. With regard to the parking lots that they're alleging, it's illegal, we cannot use them. They're BA lots, and they're mixed use, and there's also a commercial lot that is available for that. And those were put forth by my client and also at the request of the council to see how we would deal, how my client would deal with any excess parking needs over and above that or which are required under the ordinance. So we came up with a plan. We put in a letter of intent from an operator of a in business at the present time, valet service that serves the Coast Guard House and some other establishments. And any use of any area of land can be moved to another one as well, or other locations, just by virtue of the valets being able to service that. So that's not a ground upon which to deny this. The BA lots that are there are simply there as a...
I'm sorry, Mr. Doherty, do you guys think you could get your act together quietly? Because I'm very distracted. I'm trying to follow, and there's lots of paper shuffling, and I'm not sure what's going on. I'm sure it's important, but I'm very distracted.
Thank you, Glenn. And I'm also very distracted, too.
Sorry, Pat.
Oh, sorry. I've learned to block it out. It's been a couple of years now, so it's pretty easy for me to do that, but I do understand the frustration. In addition to the other allegations that were made, there aren't two liquor licenses on one lot. I mean, you heard Mr. DeSimone talk about, although he was in error in alleging that Mr. Durkin subdivided the lots were subdivided. And there's a 237 and a 237A. Oh, there's a liquor license on 237, which is the Narragansett Grill. There's a liquor license on 237A, which is the Break Hotel. And there's no merit to the allegation that there would be two licenses on one lot because they're registered, they're taxed, they're in different ownership, and they're fully conforming in all respects with all the requirements of zoning and planning. So that's another attempted, diversion. In addition to that, there are other issues. I'm not sure what he's alleging about 5813. I don't have the benefit of having it before me, but if it's about parking and if it's about the, a special use permit, these issues have already been dealt with in the first issuance of the license to the lot and also before the zoning board. Insofar as any extra use of additional land, that's going to be utilized by a valet service. There's plenty of properties on which that could be moved if it were even an issue, which I say it is not. We do also have the ability, because of the nighttime operations, to utilize the present location of Iggy's. There's plenty of parking in the back of there that could be utilized as an ulterior, or an alternate place for valet parking. So these issues here, again, I sat through quite a tenuous zoning board hearing at the last proceeding before here, hearing all kinds of crazy arguments then. I allege that these arguments, they have no merit. The facts are incorrect. The law that they're alleging is not perfectly stated either, and it's not adequately stated. In fact, my client has built the hotel. It's been built out in reliance upon these things. We have a valid zoning decision that was not properly appealed, upon which the hotel was built. And what they're trying to do, for the life of me, I don't know what these people are trying to do behind me. As an accommodation to try and make it less intrusive to the neighbors, at the planning board and at the zoning board, we offered and in fact relocated 5 employee parking spaces that were going to be directly across the street from Mr. D'Ambra, directly across the street. We moved them onto an easement on the Narragansett, we were filing the easement on the Narragansett property, Narragansett Grill property, as a means of trying to get some of the congestion away from them. That doesn't make them happy. we've enhanced the landscaping, and we've enhanced the architecture, and we've done things to make
Mr.
it
Doherty, can you
much-
just keep it to the
Yes,
the
all right.
facts here?
Okay, so, but that's the basis really of why you're hearing this. They will stop at nothing to do anything to put the screws to my client, and I allege that that's in a vendetta, and also just out of sour grapes on a case that's been going on for Mr. D'Ambra since 2006. And he hasn't won, and he won't win on this. If you have any questions about what I've said, I'd be more than happy to answer.
Thank you. Mr. Mr. DeSimone, Mr. D'Ambra?
If I could just respond, first of all, I've only been involved in this case for about 3 weeks, but secondly, your code 5813, you can ask your solicitor, I'm sure he will tell you that 5813 does not permit a liquor license in that zone. And that's where he's at. He's in a BA zone. It doesn't permit it. So I don't think there could really be any dispute about that. And secondly, you know, I bet the hearing's all over. I've never heard anybody say, well, I'm going to use this lot. There's a lot of spaces at this other lot without giving you a parking plan. It makes no sense to me. So I would submit that it's really not ripe for adjudication tonight. At least you should require some type of specificity in these plans. And secondly, he's under violation now. That's why he's at zoning. So to say that you know, everything is kosher with that, I don't believe that's accurate. But I think the most important thing is it's not permitted in the use. So that's a fact that you could just easily look up. I'm sure, Mr. Callahan, you probably have that on your computer there. I'm sure your attorney probably can tell you that. It's just a fact that has to be reconciled, and there's really no rush for you to make a decision now. He can't have a liquor license in that zone without going to zoning. So why would you grant something that's against your own ordinance?
So
Makes no
Mark,
sense.
do you know that answer?
Off the top of my head, I don't. I suspect he's probably talking about the code says restaurants and taverns require special use permits in certain zones. This was approved as a hotel and accessory restaurant, which is permitted, I think, in this zone as a special use permit. That was litigated in the Superior Court with a decision upholding the zoning board. I think that's the premise upon which all the zoning appeals and liquor license have gone forward. Hotels permitted by special use permit. It was granted with an accessory restaurant use. That was upheld in the Superior Court. Went to the zoning board for some modifications. A council, I'm not sure it was you guys, or I guess it was you guys, granted the license. And now they're back on zoning issues before the zoning board relative to what was constructed, not constructed. Does it meet the plan, not meet the plan? Does it have the parking, not the parking? But I think as far as the record right now indicates, the town's position is it's been appropriately zoned and approved for a liquor license, granted, appealed, no reversal on appeal, and presently there's zoning issues on compliance that are going on before the zoning board. Those will play themselves out in the appropriate
But
form.
not related to use.
I don't believe the use is an issue. I haven't, until I heard it tonight, didn't know it was an issue, but my, initial reaction is I don't believe it's an issue, and, we've already acted upon that some number of years ago, and you've actually granted the license on that premise. No one's appealed that, so the license itself exists for this property on the use. The zoning issues are going to play themselves out of the zoning board. You could clearly, condition the granting on compliance with whatever the zoning board decides and making sure they comply with all the, whatever the ultimate decision is, if you so choose.
Well, if I could just respond, it seems to me that you could just look up the ordinance yourself and get a specific written ruling from him. But I can tell you that I read it. I had a couple of experts read it, and they told me that a bar is not permitted in that zone. I read it. It specifically says it in your own ordinance. And secondly, he's not applying for a special use permit for a liquor license in his current application. He's leaving it silent, and he's telling the zoning board that you people already gave it to him. It's not even being mentioned in the zoning application currently. So, I mean, I heard of home court advantages, but how do you just ignore the whole thing?
Does Bonneview have, is it in a different zone, or is it they have their own special use permit?
I believe they have a grandfathered special use permit. In his plans, he's showing an outside bar. I don't even think that's allowable in that zone. You can't have an outside bar. So, I mean, I would just submit,
We're ready to vote on this.
Mr. Doherty, you have your chance. You know how it works.
you know, Mr. Callahan, I referenced the ordinance for you. I brought it to your attention. I'm sure you'll do your due diligence, but that is the fact. What was appealed in 2003 was appealed for different issues. He never applied for a use variance for the liquor license. So I gave you that fact. You have it, probably you have a recording somewhere. So, I mean, that's the fact. If you want to vote, you're free to vote. I would just suggest that you get a written opinion from your attorney, because I looked at it, I saw it, I consulted attorneys, zoning experts, and they came to the same conclusion. I wouldn't waste my time here and tell you something that I didn't think was true. So, you know, Mr. Doherty could do all the explaining he wants for why people are objecting, but the fact is they have the right to object. And, you know, I brought that to your attention, and unless you have any other questions.
Do you have something in writing from an expert we could take a look at?
Yes, I do, actually. You want to take a peek at it?
Probably need to submit it as an exhibit, Mr. DeSimone, just so it's part of the record.
I can't tell.
As soon as the council sees it, you can take a look at it. Pardon me?
Mark, can you take a look at it too?
Yeah,
Can you take a look at it?
Yeah.
Have him look at it first, yeah.
You know, and if I may, while you're marking that, in the zoning application currently pending, he never applied for a special use permit for parking for the valet lots that he claims that he's going to use. The only parking that's shown in the zoning board is parking within the lot 237A, and then the 5 spaces that I've already referenced where the 1200 Ocean Road establishment is. There's no reference to any, you know, supplemental parking in the application. So I would just bring that out to your attention. If Mr. Doherty, I'm sure he'll agree with that, but, okay, well, I have the plans right here. I could give him, I could make that an exhibit as well. I would just draw your attention to the first couple of lines there. That was prepared by Peter Carnavale, who has been a zoning official in the city of Providence for 40-some-odd years. He's well-respected throughout the entire state. And so I would just refer that to your, for your edification. And he is one of our experts who hasn't testified yet in front of the zoning board because the applicant goes first.
Mr. Diambra.
Thank you very much, Mr. President, and good luck in your election tomorrow. I know you'll do your father proud if you get to serve in the same chamber that he served in. I just want to respond to a few of the comments made by Mr. Doherty regarding this being a personal vendetta on my part or my family. Nothing could be further from the truth, and Mr. Doherty knows that full well. For him, as an officer of the court, to characterize what any legitimate property owner has as formal rights to object as strongly as the law permits one to object is inconsistent with the oath that he took as an attorney to properly represent people. I certainly, as a property owner in this town and as a 32-year resident at the address in which our current summer residence is located at, has the legitimate right to use and exercise every opportunity that we have. I want to clarify a few points that Mr. Doherty made. He claims that we have been attacking Mr. Durkin from day one. Mr. Durkin was not the original applicant when the inn was first proposed back in 2004. It was Mr. Baptista who sought to be able to build the inn. Finally, in the end, Mr. Baptista chose not to. He then turned the ball over to Mr. Durkin. What Mr. Durkin has proposed, since the inn was, yes, approved, are substantial changes to the footprint, substantial changes to the building as it was originally approved, substantial changes in the form of special use permits of one variety or another. All of them are dutifully right now being argued before the zoning board. Only one meeting has been held. For Mr. Doherty to characterize the opposition as minimal is again an understatement. There is considerable opposition to the special use permits and variances that Mr. Durkin is seeking to change the character of the inn as it was first proposed in 2007. That will continue Monday night before the zoning board. Another legitimate forum for an abutter, a property owner, to air their objections. So again, this has nothing to do personally between me or Mr. Durkin. What Mr. Doherty fails to mention is that all of the abutters, including myself, have joined together to, in fact, they have asked me always to be the spokesman, and I've readily accepted to do that. But they are here as well. Their names are on everything that has been submitted to the courts as well, and Mr. Doherty fully knows that. And if Mr. Doherty has an objection, he can object to what I have to say. I wish he wouldn't interrupt while I was speaking. I have several documents that I'd like to introduce as exhibits myself. Mr. Doherty mentions about the division of the property, that Mr. Durkin did not do that. He is correct about that. The property was divided into two lots, 237 and 237A. As Mr. Doherty knows, the conditions that were established on lot 237 continue to be applied to 237A. I have, and I'd like to present as exhibits, zoning board decision of July 10th, 1998, June 28th, 1999, and a zoning board decision of March 26, 2003, that lays out many conditions relevant to parking requirements and the use of the grill with respect to the distribution of liquor on the site, including prohibitions on outdoor entertainment, time restrictions, etc. And I raise that, quite frankly, because Councilwoman Bonanno, you, when the liquor license was first proposed, established conditions that are inconsistent with 3 zoning board decisions, prior decisions relative to lot 237. So what I would like to do is to introduce these as exhibits and be part of the record before this council.
We'll make those exhibit 2A, 2B, and 2C altogether.
Now, what I'd like to do is also comment on the parking plan. The parking plan really is no parking plan whatsoever. I want to introduce as an exhibit a Department of Building Inspection correspondence dated July 21st, 2014, subject overflow parking lot. This is a violation notice given to 1191 Ocean Road by the building inspector that references overflow parking for the Break Hotel is located in a coastal and freshwater wetland overlay district. A special use permit is required. The Table of Use Regulations 6.1, 6321 prohibits an off-street commercial parking lot in a residential zoning district. A zone change through a public hearing by the town council may be required. I'd like to introduce, this is an exhibit also relative to, and it's addressed to Mr. Durkin. Unfortunately, I have to mention his name since it was addressed to him, relative to overflow parking lot 1191 regarding the break. And I make note that Mr. McSally and the town manager were CC'd on this correspondence.
Exhibit 3. Thank you.
Also, Mr. Dougherty, in a supplemental parking plan that has been submitted twice to this council, references lot 282 as being lots 232 and 286. 232, what he failed to tell you, which is the Iggy's lot, is limited to 18 spaces. There are 11 cottages and 1 house on there. That makes up for 12 of the parking spaces. Iggy's, the restaurant, is designated with 6. There's only a total of 18. So there are no further cars that can be parked on that location. In addition, he references lot 282. Lot 282 was a merger of 3 lots, which has a house on it, which Mr. DeSimone has already mentioned as being prohibited. But I want to make note, and I want an exhibit to be introduced as well, that that lot is is taxed at residential. And it's identified in the most recent tax records of the town as R10. So although they're referencing it as commercial tonight, your tax records say it is an R10, and therefore parking cannot be used on that, without, again, going through certain procedures. But again, from the tax records of the town of Narragansett, this is a printout of that location as being zoned R10, residential.
Thank you. Exhibit 4.
Mr. Callahan, as I had mentioned to you, I wish you well in your race to become a member of the Senate. The Senate, as you know, is the most deliberative of any legislative body in the state of Rhode Island. And that's what its tradition has been known to be. There is no need for this council tonight to rush to approve this particular license, nor should it approve the license for the grill for very legitimate reasons. Mr. Durkin is proposing to take 3,000 square feet from lot 237 and assign it to 237A. That has serious implications regarding 3 previous zoning board decisions. Again, if you're going to renew the grills, then you're going to have to renew it subject to whatever decision the zoning board makes following the meeting of next Monday night, November 10th, which I don't think will be the last meeting on all of the changes being made by, or being requested by Mr. Durkin. So, I think I have one final point to make. Yes, the parking plan also referenced 24, in Mrs. Durkin's original application for the tavern license, she referenced 24 spaces to use as parking for the tavern. Those 24 spaces she referenced were part of the 2007 decision. The 2007 decision clearly identified those 24 spaces for use by patrons of the inn and any of the employees. No spaces were allotted for any kind of tavern to be open to the public. There is totally insufficient parking. This parking plan is virtually non-existent, and the overflow parking that he really is mentioning as a possible site has been cited by your building inspector back in July as in violation, and has also been cited, to the best of my knowledge, by DEM, and DOT has also raised questions about a cut or a curb cut that was made to that overflow parking lot without applying to make that cut. So DEM has come down and has cited that same reference that Mr. Santilli, those lots that Mr. Santilli cited, which were identified by Mr. Durkin as his overflow parking lot for the break. That's in that document from your building inspector. Those are not my words. Those are the words of the building inspector himself. Thank you very much.
Thank you. Mr. Dougherty, let's make it rapid.
It's important to address some of these things. This is all, it's not news to me. It's more more smokescreen to the council. First of all, there are no violations at the break. We have not been issued any notice of violations. Due to the complexities of the construction and the build-out and the intent to try and make the project the best project it can be within the confines of the decision, we approached Mr. Santilli, or Mr. Durkin did, during the course of the construction, said, hey, we've made some minor changes. We haven't further encroached into any setbacks. We haven't done anything, but we need to know if this is okay with you. And if not, we need to know what it is that you may take issue with so that we can go before the zoning board. And the reason for that is because as part of the decision which granted the special use permit for the Break Hotel, the decision that we went back for in 2013, whereby the project was sought to be built in a better fashion with a bigger construction budget to make it nicer, to make better accoutrements to it so it was nicer from the outside as well as from the inside, in an attempt to make it blend in nicely with the neighborhood and make it a destination for the town. We went back to try and seek some additional relief, which was granted by the zoning board after a full hearing and full review. So part of the decision was that the project be built out in strict compliance with the site plan. Now, the problem that you have with something like that, with the requirement, is under the zoning ordinance, when you go in for an application for relief and you have a pre-application meeting, it's up to the zoning official as well as the director of community development and his staff to come forward, meet with the applicant and say, okay, well, let's talk about the property. The staff knows a bit about the surrounding areas and also the needs of the particular zone. And they detail for the applicant exactly what they want included in the site plan. Now, that doesn't mean that every single thing that you're going to be doing on the property is going to be narrowed down to what that specific item is in the site plan, but they didn't require the level of detail at the pre-application meeting and the site plan that was brought before the board for review that was contemplated in the final build-out of the project. But we are in no way under any notices of violation for the break property or the build-out as it is now posited. The issues that were before the board now are simple modification to the condition of strict compliance with the site plan. A couple of minor things due to the health department regulations and the desire to make it a better, safer, more clean facility. A hot tub that was originally put by the applicant in 2006.
Mr. Doherty, can we move this along?
Well, no, this is where he's going on. This is what these big things are. They moved it outside of the pool so that the water sources didn't cross-contaminate. And because they're different temperatures, different filtration, it's much better, safer, and cleaner to do it that way. In addition, there was a minor shifting on the footprint of one of the pool buildings that didn't encroach into the setback anymore. Still, it's maybe a half a foot off. The pool was made smaller so that we wouldn't increase.
Mr. Doherty, we don't need to hear about the pool and the changes. That's not the issue right now.
Okay. Well, then let me get to the heart of this. So there are no notices of violation. We brought that forward because we wanted to be in full disclosure to the board as to what was being built out, and we wanted to not have any issues with the certificate of occupancy. I'm confident we're going to prevail on that. We don't need a use variance. This was litigated up to the Supreme Court, and the solicitor was there with regard to this at the Superior Court level as well. The court found that the hotel, the restaurant, were integrally part of the same use, and it's defined under the ordinance as a hotel has restaurants and bars included within that contemplated use. That issue was brought up all the way to the Superior Court. It was denied. The argument they're making now was denied. So that's res judicata. The thing's already been decided. With regard to the allegation that the liquor establishments are not for the use of the patrons, that's nonsensical. It's not huge space that we're putting into here. We showed the plans to you when we were here on the transfer. We put the schematics up there. It's not, it can't attract a huge crowd. We're constrained by the fire code and the limited seating in there. So we don't require extra parking. We're not engaging in an additional use on the property. And the zoning, the special use permit that was originally granted and that was and another one that was granted included those uses within the confines. And there's, right now, what they're attempting to do is they're attempting to muddy the waters here before you by bringing up issues that are only properly before the zoning board. And as you may recall, when I came here for the initial liquor license, we talked about this in great detail, about the separation of powers between the town council sitting as the licensing body and the zoning board sitting as the body that determines the appropriate uses for land. Special use permits run with the land. This property has gotten a special use permit. It got one before it was subdivided. It got one when the Break Hotel was originally permitted. And I read from the transcript of the proceedings before the zoning board where they did talk about the service of alcohol at that hearing. And that was part and parcel of the special use permit that was brought before it in 2006. So we don't require a use variance. We don't require any additional special use permits. They've already been granted. We had a long discussion about this at the initial hearing. Your solicitor weighed in on that. Okay. And with regard to the allegation, I'll just clear up a couple of quick things. We're not carving off 3,000 square feet from the Narragansett Grill and putting it onto the Break Hotel. There's a 400 square foot subdivision. I think it's 391 feet. The properties still remain in full compliance with zoning. There's no issue with regard to that. And one last thing that I'd just like to correct. With regard to Mr. D'Ambra, I didn't call that a personal vendetta. I called it sour grapes. With regard to Mr. Gravino, I did say it was a personal vendetta. And that's, I think, what's going on here. It's sour grapes. They didn't want this hotel built. It's going to be built. We need the liquor license. I believe we're appropriate and proper. Oh, and with regard to the unsigned, undated allegation of this expert thing that has handwritten to JD-esque from Peter C., this is all wrong because this goes against what was in the Superior Court decision. It talks about the fact that they're saying if a bar is not permitted, it's not an accessory use to the hotel. It is. It's already been decided. That went up to the court. We wouldn't even have a zoning decision in effect if that were not the case. So this, first of all, I object to this because it's not signed. You don't even know who the heck these people are. And there's a lot of supposition in here that simply isn't true. So again, I am amazed at the level of intensity of the opposition here. And I can affirm to you that the arguments that you've heard about the need for additional zoning relief are not true. If they were, then we're not going to get our zoning decision at the zoning board. But we already did. And I urge you not to fall for the smoke screen and let this business get its liquor license or continue to hold its liquor license and let it be a successful thing in the town.
All right, any further discussion, comments?
Mark, do you want to say anything about that? Anything at all before we vote on this 5813? I mean,
You have options to do what you want to do. I mean, you could table it until zoning acts, or you can act upon it subject to zoning, straightening out whatever the issues are relative to the parking, to the structures, et cetera. As I said before, I've not have not researched all this. I have some recollection of this because having lived through it. Basically, you've got a use that's been litigated and the Superior Court decision upheld the Zoning Board of Review. You've had a liquor license that was heard before you, granted, there was opposition to it. That license was subsequently transferred. There was opposition to it, no appeal. So you have a license before you that you're looking to renew right now. So the question is, one of two paths. Do you defer, or do you approve the renewal subject to them meeting, the licensee meeting whatever zoning requirements are imposed or required as a result of the ongoing hearings there. I think those are the two courses of action at the moment.
Yeah, I mean, I would prefer that one. I mean, we're in the middle of the license, want to make sure I want to support it, but I just want to make sure there are conditions in there in case something should go awry.
I think that the only issue before us is the renewal of the license. Just to simplify it, that's the only issue before us. We already granted the license. Now, I think that we need to vote as to whether we're going to renew that license or not. I think that's what we've come down to. And I'm ready to vote.
How would the conditional work, Mark? I mean, we have obviously a changing body right now. It's a little awkward in that respect.
In terms of, I'm not sure I followed you, in terms of if you approved it conditionally?
Right.
If you voted to approve it, you're approving it subject to state and local laws, so even if you don't say what the zoning board imposes, that's going to be the requirement that we impose from an enforcement perspective. If the zoning board says you got to do X, that's going to be the
And it doesn't matter who's sitting here. I mean,
Yeah, the
that just-
zoning board's not turning over, right? So,
Right, so I think that's.
So
And
I
I-
think,
and
yeah, the action on the license you guys can take, regardless of the fact that, you know, at least 2 seats change before the next meeting. If you decide to defer it, then you're probably, that new body's going to hear a lot of the same arguments again at that point in time, or they're going to hear the renewed arguments on the zoning issues.
and I do have a recollection on the tail end of this as well, where, you know, a lot of this was litigated, I recall, and we did get through a number of, we would not be at this place. We would not have granted a license had we not gotten to the point where there had been the merits to actually grant the license, right? So we are in the place where there is a valid license, and we are in a position to renew the license, and to the extent that there's zoning questions, that's the purview of the zoning board, and to the extent that we renew the license, I think it's safe to do that subject to satisfying the conditions of zoning.
Agreed.
It's fair to me.
Fair to me.
All right. Any further discussion? All right, let's take the first, others, and this one first. Motion to renew the Class B Tavern Alcohol Beverage licenses for INP Beverage Services, Pry X Beverage Services, and Recreation Partners, Inc. for Class B Tavern Alcohol renewals. Someone can make that motion.
I'll make that motion.
Second.
All in favor?
Aye.
Now we'll take the break. Let's make a motion to approve the break renewal of the Class B Tavern license, subject to approval from the zoning board. Any further?
I think James, I'd probably make it just subject to them meeting whatever conditions may be imposed by the zoning board as a result of the ongoing hearings before them.
See, I don't understand why we're doing that.
Well,
That isn't what's before us. Why are we bringing that into it? It doesn't make sense. It doesn't make sense to me.
You don't have to. I offered it as an alternative. That's all I offered it as.
Okay.
Mr. Durkin?
I mean, this is just gonna make, you guys you guys approved the liquor license. We did all of this stuff to get the liquor license. Now, the smoke screen's coming up, so you're giving them an opportunity after you've already approved the liquor license to make further arguments. It's putting us, this is just always putting us in this like little situation where nothing's clear, you know what I mean? Everything was clear, we had the liquor license. It's very clear that you can have a liquor license with a hotel. We weren't required to have extra parking. Susie suggested, do you have extra parking? Can you put it? We did on a BA zoned lot, not across the street with the violation that Mr. D'Amber is calling. That's a residential lot that was never going to be used for overflow parking. Mark told me when I called him that you can't use a residential lot for overflow parking, although Mr. D'Amber's client, the Bond View, has all residential zone parking around their property. So it's just putting us, like, you don't understand what like, you're asking, like, should we do this? But you just have to think about.
Jim, we were going to vote yes, just with conditions. I mean, I don't think it...
Yeah, but I don't, see, I don't, that's the problem I'm having with this. Why are we always dealing in the hypothetical? What if, what
Yeah,
if,
why
what
would-
if? It just doesn't make any sense to me. And not only that, we're sitting as the licensing people here. If there's a problem with his license, if there's too much noise or too much drinking or it's not working out, we can revoke that license. Or we could have him in for renewal next time up and put conditions on it if there's a problem with it. We're just complicating stuff here.
But what, you know, say if I go to the zoning board.
And I do understand very well, I understand very well where we're at and what we should be voting on.
But I mean, like, if I go to the zoning board and the zoning board says,
But you're already there, right? You're already there, aren't you?
I'm already there, and
So
I'm not
once,
there
if you
for-
get, if you get approval for that, then there's gonna be no issue with the
yeah,
license.
but Jim, that has nothing to do with the liquor license, though. So why make it, it's
All
like
right,
moving a building one
I just want to
inch.
vote, I just want to vote on this. Thank you, Mr. Durkin, I appreciate it. Let's just vote on the current motion, yea or nay, with the conditions that Mr. McSal, that's the current motion. So let's vote on that. If that fails, we'll go back to something else. That's the way to do
So,
it.
Mark,
That's the way to do it.
Can you just...
I'd like to, can I amend the motion?
Well, let's get the motion on the floor first, Mark.
I think what I said was it'd be subject to them complying with whatever conditions, if any, are imposed by the zoning board as a result of the ongoing hearings before the zoning board right now.
So I'm going to make that motion.
Right. I think that motion's been made, correct?
Yep.
Correct.
All right.
Second.
All in favor?
Aye.
Aye.
All opposed?
Nay.
All right. Moving on, to Class B victualling alcoholic beverage licenses renewals. There's 22.
I'll move that motion.
All right.
Second.
We have the Adirondack Development Company, Buster Crab's Burger Shack, Amy Mason State Street, Hanks Down South, Caterina's Italian Village, Boston Neck Road, Caterina's Village, Champlin Seafood Deck, 294 Holdings, Wheelhouse LLC, Diamond Arturo, number 140, Arturo Joe's, GFL, 140, Pancho O'Malley's, George of Galilee, number 250, Hammerhead Grill, Bonneview Inn, Mainland Grill, 1200 Narragansett Grill, Mariner Grill, 140, NRI Ventures, Perry's Neighborhood Bar and Grill, 140, New Dragon, number 80, Pelly's Property, Boston Neck Road, 909 Pelly's Place, Pier Inc., Portside Restaurant, 221, Sags Enterprises, Boone Street, PJ's Pub, number 135, Sand Hill Associates, Sand Hill Cove, Charlie O's Tavern at the Point.
I'll move that motion.
Second, with a question, actually. So a number of these, and I realize we're only on October 30th, and these go forward December 1st, but a number of these tend to not have a number of the fees and taxes paid. Do they generally come in like right before, or, okay. So subject to, obviously, the fees and taxes. Right, the motion is subject to local and state regulation. Okay.
All in favor?
Aye.
Moving on to, I'm sorry, I skipped.
You got to add South Winds in Spain, the ones below Soho.
Sorry about that. Southwinds Corporation, Spain and Narragansett, TRG2 Inc., number 91, Trio LLC, number 15, and Twin Willows, 865 Twin Willows. The two that are not renewing are Constantino's, Basil's, and Soho Restaurant, Pier Marketplace, number 21. So I'm sorry to do that again, with all the ones I mentioned previously, plus those extra 1, 2, 3, 4, 5. Someone can make that motion?
I'll make that motion.
Second.
All in favor?
Aye.
All right. The Class D Club Alcohol Beverage License renewals, there are 5. Dunes Corporation, Boston Neck Road, number 137, Dunes Club. GBC, Sand Hill Cove Road, 220, Galilee Beach Club. Medituxet Improvement Association, South River Drive, Medituxet Yacht Club. And Pettisquamscot Lake Shores Improvement Association, Woodser Road, Pettisquamscot Lake Shores Improvement Association, and Point Judith Country Club, Windmere Road, 150, Point Judith Country Club. Somebody can make that motion for those 5.
I'll make that motion.
Second.
All in favor?
Aye.
And last, we have the Class D alcohol beverage licenses subject to compliance with local and state regulations. Let's see.
James. Bonjour's Beach Club, excuse me.
All right, so the following license holds are granted on June 16, 2014 for the 2014 season Friday entertainment for the months of August and September until 11/30, and the request for continuing entertainment will be reviewed by the Town Council at renewal time in November 2014. Do we have any comments or?
I don't believe we've had any complaints, and this, is, as the council may or may not be aware, was appealed to DBR. Subsequently, the appellant withdrew the appeal, so the appeal to attack the restrictions or the granting of the license with the new stipulations was withdrawn. So that's a valid license with those conditions, and there were no complaints that I'm aware of during that time period from this summer.
So will it be renewed for next year or not?
You'd be renewed without the requirement for a further review unless you impose that. So it'd renew it with those conditions that have been listed by you guys back in June of 2014.
And Mr. Raffinelli is here. Do you have any comment on the renewal of the Bonnet Shores Beach Club entertainment license on Friday nights?
Good evening. I'm simply here as a, not simply, I'm here as a board member of the Bonnet Shores Beach Club, along with Carol O'Donnell, who's also a board member, and Zach Stedman, who is the Bonnet Shores Beach Club manager. So we're just asking to have this approved.
So it would be with the same stipulations the council gave permission to increase the entertainment, so July and August. I'm not going to read them all, but all you're doing is reviewing compliance with those stipulations. Were there any problems during the summer? And there were none that were reported to us. So I think you're free to renew the license, and there'll just be a normal license holding it with those entertainment restrictions.
Great. Thank you. Any further comment?
No, for the Bonnet Shores ones, those are the ones that we did for the club. They only wanted like 4 or 6, right?
Right.
And they agreed to that. That was
With
sort of...
the extra day.
Yeah.
Yeah.
Okay. I just wanted to make sure, Zach, I had that right. Okay. That's good.
So the motion is to renew the Class D alcohol beverage license, subject to compliance with state and local regulations, along with the separate conditions and restrictions. Somebody can make that motion?
I'll make that motion.
Second.
All in favor?
Aye.
Motion carries 4-0. Completely lost track of this thing. Number 9. A motion to... Number 9, new business. A motion to approve the settlement and authorize the town manager to sign a memorandum of agreement between the town of Narragansett and Laborers International Union of North America, LIUNA, Local Union 1033, on behalf of John Majika.
I'll move that motion.
Second.
Any discussion? All in favor?
Aye.
Aye.
Motion carries 4-0. Someone like a motion to adjourn?
I'll make that motion.
Second.
All in favor?
Aye.
Have a good night, and good luck, everybody.
Good luck, everyone.